Is that agreed?
Agreed.
Carried. We will now be considering Bill number 193, the Statute Law Amendment Act 2019, number 2. We will begin our consideration of Clause 1, short title. Minister Morgan, please make your opening comments.
Thank you, Mr. Chair. I'm rejoined by Kara Moen, Crown Counsel, Legislative Services Branch. I'm pleased to be able to offer brief opening remarks concerning Bill 193, the Statute Law Amendment Act 2019, number 2. This bill will make housekeeping updates to various acts for the purpose of modernizing their provisions. In particular, the bill will replace references to department with ministry, update references to the Federation of Saskatchewan Indian Nations with sovereign Indigenous nations, replace gendered language such as workmen and foremen with gender-neutral terms like workers and forepersons, and make other housekeeping updates to individual acts. Mr. Chair, this bill fits with the government's policy of bringing forward statute revision pieces annually to ensure that statutory language is updated and modernized on an ongoing basis. Mr. Chair, with those opening remarks, I welcome your questions regarding Bill number 193, the Statute Law Amendment Act 2019, number 2.
Are there any questions? Ms. Saar.
Thank you, Mr. Chair, and thank you, Minister, for your opening remarks. Could you provide some information as to why the language ministry is now favored over the language department?
Good question. I think it goes back to when, in 2007, when we formed government, we started referring to departments as ministries, and I don't know whether.
Yeah, it's if you actually track the history in Saskatchewan going back, it is one of those things where, with the changes of government on a particular stripe, there is a difference between departments and ministries. There's an argument that it reflects the British model versus the Americanization of the model, with the department being a more American approach, ministry being a more classical parliamentary approach. But it has been just the reality in Saskatchewan that there's a preference for one versus the other over the with the changes in administration.
Thank you.
Are there any other questions? Seeing no other questions, Clause 1, short title, is that agreed?
Agreed.
Carried. Clause 2, is that agreed?
Agreed.
Carried. Clause 3, is that agreed?
Agreed.
Carried. Clause 4, is that agreed?
Agreed.
Carried. Clause 5, is that agreed?
Agreed.
Carried. Clause 6, is that agreed?
Agreed.
Carried. Clause 7, is that agreed?
Agreed.
Carried. Clause 8, is that agreed?
Agreed.
Carried. Clause 9, is that agreed?
Agreed.
Carried. Clause 10, is that agreed?
Agreed.
Carried. Clause 11, is that agreed?
Agreed.
Carried. Clause 12, is that agreed?
Agreed.
Carried. Clause 13, is that agreed?
Agreed.
Carried. Clause 14, is that agreed?
Agreed.
Carried. Clause 15, is that agreed?
Agreed.
Carried. Clause 16, is that agreed?
Agreed.
Carried. Clause 17 coming into force, is that agreed?
Agreed.
Carried. Schedule, is that agreed?
Agreed.
Carried. Her Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows the Statute Law Amendment Act 2019, number 2. I would ask a member to move that we report Bill number 193, the Statute Amendment Act 2019, number 2, without amendment.
I so move.
Mr. Dutron moves. Is that agreed?
Agreed.
Carried. We will now be considering Bill number 205, the Children's Law Act 2019. We will begin our consideration of Clause 1, short title. Minister Morgan, if you'd please make your opening remarks and introduce your officials.
Thank you, Mr. Chair. I'm joined by Maria Marcato, Senior Crown Counsel, Legislative Services Branch, Ministry of Justice, and Kara Moen, Crown Counsel, Legislative Services Branch, Ministry of Justice. I'm pleased to be able to offer opening remarks concerning Bill 205, the Children's Law Act 2019. Mr. Chair, this bill repeals and replaces the Children's Law Act 1997 to update the parentage provisions to address situations of assisted reproduction, surrogacy, and more than two parents, and to make changes to mirror amendments to the Divorce Act. In its report on assisted reproduction and parentage, the Law Reform Commission of Saskatchewan made recommendations respecting amendments to the parentage provisions in the Act. The report made 11 recommendations, which included replacing the terms mother and father with parent, allowing intended parents to enter into a parentage agreement or surrogacy agreement with independent legal advice, allowing up to 4 individuals to be acknowledged as parents without requiring a court application, and allowing a parent to apply for a declaration that his deceased spouse is a parent of the child if the child is conceived after the death of the spouse. Mr. Chair, this bill creates additional protections for children and recognizes the impact of new technology on parental autonomy. This bill will increase certainty and remove obstacles for families when they are making important decisions about reproduction and their children. This bill also updates the Act to ensure consistency with the Divorce Act. The Divorce Act was amended to modernize the language relating to custody and access, highlight the best interests criteria with a focus on negative effects of family violence, introduce new measures to assist the court in addressing family violence, and establish a framework for the relocation of a child. Mr. Chair, the new Act incorporates similar provisions to ensure families are treated the same by the courts regardless of marital status. Mr. Chair, with those opening remarks, I welcome your questions regarding Bill 205, the Children's Law Act 2019.
Are there any questions? Ms. Sauer has the floor.
Thank you, Mr. Chair, and thank you, Minister, for your opening remarks. There's several pieces to this legislation. I want to make sure that I do justice to as many of them as possible. The first bit is, of course, as you had mentioned, the changes around parentage and that the ability to reflect the more modern families that we're seeing today. You spoke a bit about the Law Reform Commission report. Were there any recommendations made by that report that aren't included in this legislation?
Thank you for the question, Maria Marcatos, Legislative Services. The Law Reform Commission made 11 recommendations in their report, and all were followed entirely except one, which was followed partially, and that was with respect to what we're calling parentage agreements in the Act, so where there are up to 4 parents and the birth parent intends to parent the future child. The Law Reform Commission recommended that everybody who is a party to that written agreement receive independent legal advice. That's not in the Act, but there will be prescribed requirements in the regulations, and we're likely to add it there.
Why was it determined that independent legal advice was not needed for all of those individuals?
Well, as the member knows, in the normal course, an agreement isn't required and independent legal advice isn't required. So in this case, where the birth mother, or the birth parent, as we're calling it in this Act, intends to parent, we weren't sure that we would include that at the outset, but we wanted to consult on it a little further with members of the bar.
So is that consultation work still ongoing?
That consultation work will happen when we get to work on the regulations.
How do other jurisdictions handle this area of law?
Currently in Canada, 2 other jurisdictions have provisions around parentage and assisted reproduction, BC and Ontario. You'll see that our provisions are closer aligned to Ontario, and that was partly because they're newer. They're from 2016, where the BC provisions date back to 2011.
Thank you. And as has been discussed by my colleague, Mr. Forbes, the member for Saskatoon Centre, who knows the history of the work leading up to this legislation better than I, and he's been a strong advocate for it. And in his remarks when he allowed this bill to move to committee, passionately calls this Alice's Law based on the individuals who advocated for it first through him or for him. I would just encourage anyone who is looking into this legislation and as a result looking at the discussion we're having this evening to also look at Mr. Forbes's remarks when he was allowing this legislation to move to committee, because he did the history, I think the history of the work leading up to tonight, a lot of justice and more justice than I can do this evening. So I wanted to make sure to get that on the record so that anyone looking into this discussion would also look at that discussion as well.
I think that's a fair comment to make. I wasn't able to hear Mr. Forbes' remarks in the House, but I did speak to him afterwards, and he did mention that he had spoken to it and that he was a passionate believer in this. I also met with Mr. Forbes and some of his constituents who will be direct benefits of the piece of legislation. So I would certainly want to thank him and his constituents for their support.
My colleague has a question about this particular area of the legislation, so it might make sense to allow her to ask the question now, and then I'll continue to ask my questions.
Ms. Rule, you have the floor.
Thank you, Mr. Chair. Minister, today I was listening to the radio, and there's an interview about surrogates and surrogate mothers and some of the gaps in law as it relates to surrogacy. Is there any work going on within the ministry right now looking into the rights of surrogate mothers and the 3 parties there, which would be the child and the surrogate mother and then the future parents?
Matter initially was sent to the Law Reform Commission, who completed their work. So their work is largely finished at the Law Reform Commission. But I think, given that we're one of the earlier provinces to adopt this, we would be well served to continue to monitor within in the ministry as to ongoing cases that come out of other provinces, as well as other issues that might arise. I think we're in the earlier stages of litigation that will come out of assisted reproduction, and I think your point's well taken that we should continue to watch it.
Ms. Saar?
Thank you, Minister. As you had mentioned, also in this legislation, there is now a definition for family violence and some work around having that be a consideration around family matters as it relates to children. Can you speak a little bit more about those provisions and what this will mean in terms of changes to the law as it currently stands in Saskatchewan?
And initially, it makes this a factor definitely to be considered by the courts, and I think reflects the position that the province wants to take, that violence within a family unit is something that's unacceptable and needs to be deterred in every possible manner. But I'll let Maria speak further.
Thank you, Minister. These changes to the best interest provisions are modeled on those in the Divorce Act that are going to come into force July 1st of this year. And they make the best interest provisions paramount. So in addition to including a list that's not exhaustive. It includes family violence explicitly, and then in 10 sub 4 sets out the considerations around family violence that the court will consider, so the nature and seriousness and frequency of family violence and when it occurred. So that's a really important one around type, severity, and frequency, and also whether it was recent or a long time ago, and whether the violence was direct violence or exposure to violence. But there are a number of clauses that are set out in subsection 4, and it was important to include those so that people who use the Children's Law Act instead of the Divorce Act, if they weren't married, the same kinds of criteria are being considered.
So is this directly mirroring, exactly mirroring what will be in the Divorce Act?
These provisions mirror the Divorce Act exactly.
And how will this, how does the ministry anticipate this will look, practically speaking, in the courts? For example, will this mean perhaps that criminal records will be more frequently sought after and requested in chambers applications? Has there been any thought to what this might look like moving forward in family law proceedings?
I think the answer is we don't know yet, because the Divorce Act provisions haven't been implemented either. But Section 43 expands the access to information provision to also talk about protection orders, which means an order made pursuant to the criminal code that restricts a person from contacting or communicating, or any other prescribed order. So maybe.
Could you provide for the record how family violence is dealt with currently in terms of custody and access applications?
So as it currently stands, there is a consideration given to violence in the home as it plays into the best interests of the child. However, this further highlights what kinds of violence that may be and how much weight that really plays into the best interests of the child. So while it is currently a consideration by the court, this emphasizes how much that should be considered.
Thank you. Another change in the legislation is around habitual residence and how that is dealt with. Could you provide some further information about that specific change?
One of the changes that's being made to the Divorce Act will allow for the implementation of the Hague Convention on Jurisdiction. And some of the work that they did in the Divorce Act was to set that up. The convention has been signed by Canada but not ratified yet. So some of the changes that are being made to this act update the language so that if at some point that convention is ratified, this act won't be contrary to the convention. So some of the provisions that you mentioned like in section 661B, for the purposes of making a parenting order, the court has jurisdiction if the child's habitual residence cannot be determined and the child is physically present in Saskatchewan. That language is compliant with the Hague Convention. So there was an update there. The previous provision was a little wordier. At section 15, although the child is not habitually resident, the court is satisfied that the child is physically present, there's a substantial connection, and generally the two options are now moving further away from either the child's habitually resident in Saskatchewan or the residence just can't be determined, whatever the court determines that to be.
Thank you. Correct me if I'm wrong, but the change in section 11, the statement that there's no presumption of a preferred parent is new for this legislation, but I believe it's not necessarily new in practice and common law. Can you provide some further information about that section?
It's not new. The provision's just been updated slightly. So the existing provision is 8C. So in making, varying, or rescinding an order for custody, the court shall make no presumption and draw no inferences between parents that one parent should be preferred over the other or the basis of the person's status as a father or mother. So it was updated because we've removed the language around father and mother.
Gotcha. One of the challenges that parents often find after separation is determining or being able to make decisions for their children when the other parent is not necessarily in agreement with that decision. And one particular one that comes to mind is around counseling for that child. Is there anything in the amendments in this legislation that would affect that challenge that many parents face?
The definition of custody is replaced with an expanded definition of decision-making responsibility. So there's more of a focus on important decisions with respect to the child. And it lists the type of decisions that can be made, though it's not exhaustive. So decisions respecting health, education, culture, language, religion, and spirituality, and significant extracurricular activities. So the parent, if one parent has exclusive decision-making responsibility, then it's likely to fall within that definition. But there isn't anything in this act specific to counseling.
Right, and correct me if this is changed, but the de facto is unless otherwise for a few different reasons. But generally speaking, de facto, if two individuals separate, it would be a joint parentage situation, so that the challenge would still be in place in terms of making those sorts of decisions, healthcare decisions, counseling decisions. So there's nothing in this legislation that would necessarily affect that. Has the ministry considered looking into how other jurisdictions handle, in particular, mental health decisions in terms of counseling for children of separated parents?
I don't think it was the purpose of this piece of legislation to focus on the longer-term requirements. Was maybe something that were there. What this was primarily intended to deal with was the parentage issue, birth certificates, custody, and I think the issues that you're raising are ones that probably should be looked at, but were not contemplated as part of this act.
Okay, thank you. Are there any next steps in terms of the issues that were contemplated in this legislation, parentage issues as an example, that the ministry is planning on looking into further?
Well, the existing regulations will need to be repealed and replaced with new regulations to complement the act, and we'll need to work on those.
I think further to your earlier comments that anytime there's a piece of legislation such as this, or in a general sense, we should regard the needs of family law as such that there should be ongoing eyes looked at it on to see whether there's other changes or other needs, and we should try and look at and adopt best practices wherever we can, and to provide the courts with the supports that they need to be able to make appropriate decisions.
Thank you. And largely speaking, with respect to the entirety of this legislation, what sort of consultation was done prior to these changes?
So the Law Reform Commission consulted extensively on their report, including public consultations, an online survey, and in-person working groups. And then the ministry consulted with the Canadian Bar Association, the Saskatchewan Trial Lawyers Association, Legal Aid, Pro Bono, Law Saskatchewan, individual lawyers, the Public Guardian and Trustee, the Court of Queen's Bench, and the Registrar of Vital Statistics. And then we also had direct consultations with the Canadian Bar Association, Saskatchewan Branch, Family Law sections.
Thank you.
The Bar Association did a seminar or webinar on it as well, so there was, certainly within the profession, there was a large amount of consultation and I think, generally speaking, favorable discussion.
That was going to be my question, actually. What sort of reaction did you receive to these changes? They obviously didn't see the legislation as we're seeing it now, but largely speaking, what sort of reaction did you receive from the bar about these general changes?
The comments that I received, and I'll certainly let the officials indicate, were more in the nature of what the timeline would be to prepare and introduce the legislation. Was the government generally supportive of it? And my indication at the time was that there was strong support for it. The cabinet had urged to go forward when went to the Law Foundation initially. There'd been some discussion in a general sense, and everybody said yes. And then when the report came back, there was internal discussions here, and there was strong support anywhere. So I'm not aware that there was anybody that was not supportive, and I don't think I received any correspondence from people that were not supportive. At least none that I recall. No, I don't. It could be that those that like it sent letters to me and those that didn't send letters to Maria Markakis. I don't know.
We weren't made aware of any concerns with the legislation. All of the responses that we received were positive, and members of the bar were supportive of the changes to mirror the Divorce Act, but also particularly supportive of the changes around parentage and including provisions around assisted reproduction. Many of the lawyers that we heard from have clients who are involved in assisted reproduction and have become very frustrated with the existing process, and hopefully this will help to streamline it a little bit.
Thank you.
Are there any other questions for the minister and his officials? Seeing no other questions, this bill has almost 100 clauses. I will be asking leave of the committee to review the bill by parts and divisions. Is leave granted?
Agreed.
Carried. Part 1, preliminary matters. Clause 1, short title. Is that agreed?
Agreed.
Carried. Clause 2, is that agreed?
Agreed.
Carried. Part 2, decision-making responsibility and parenting time, Clause 3 to 23. Is that agreed?
Agreed.
Carried. Part 3, extra-provincial parenting orders, Clauses 24 to 29. Is that agreed?
Agreed.
Carried. Part 4, parenting coordinators, Clauses 30 to 36. Is that agreed?
Agreed.
Carried. Part 5, enforcement of decision-making responsibility and parenting time, Clauses 37 to 44. Is that agreed?
Agreed.
Carried. Part 6, guardianship of the property of the child, Clauses 45 to 54. Is that agreed?
Agreed.
Carried. Part 7, child status and parentage, Division 1, general, Clauses 55 to 68. Is that agreed?
Agreed.
Carried. Division 2, recognition of extra-provincial determinations of parentage, Clauses 69 to 77. Is that agreed?
Agreed.
Carried. Part 8, general, Clauses 78 to 79. Is that agreed?
Agreed.
Carried. Part 10, consequential amendments.
Part 9. Part 9.
Oh, I missed one, sorry. Part 9, repeal and transitional, clauses 80 to 84. Is that agreed?
Agreed.
Carried. Part 10, again, consequential amendments, clauses 85 to 92. Is that agreed?
Agreed.
Carried. Part 11, coming into force, clause 93, coming into force. Is that agreed?
Agreed.
Carried. Her Majesty by and with the advice and consent of the Legislative Assembly of Saskatchewan enacts as follows the Children's Law Act 2019. Is that agreed?
Agreed.
Carried. I would ask a member to move that we report Bill number 205, the Children's Law Act 2019 without amendment. Mr. Francis moves. Is that agreed?
Agreed.
Carried. We will now be considering Bill number 206, the Children's Law Consequential Amendments Act 2019. We will begin our consideration of Clause 1, short title. Minister Morgan, if you have any opening comments, please go ahead and make them.
Thank you, Mr. Chair. I'm joined by Maria Marcados, Senior Crown Counsel, Legislative Services Branch, and Kara Moen, Crown Counsel, Legislative Service Branch, Ministry of Justice. I'm pleased to offer opening remarks concerning Bill 206, the Children's Law Consequential Amendment Act. This bill accompanies Bill 205, the Children's Law Act 2019, to make consequential amendments to the following 11 acts: the Arbitration Act 1992, the Child and Family Services Act, the Human Tissue Gift Act 2015, the Liquor Board Superannuation Act, the Mental Health Services Act, the Municipal Employees Pension Act, the Power Corporation Superannuation Act, the Public Guardian and Trustee Act, the Public Service Superannuation Act, the Teachers Superannuation and Disability Benefits Act, and the Trustee Act 2009. In each act, reference to the Children's Law Act 1997 will be repealed and replaced with reference to the new act. There is no change in substance. Mr. Chair, with those opening remarks, I welcome your questions respecting Bill 206, the Children's Law Consequential Amendments Act 2019.
Are there any questions? Seeing no questions, Clause 1, short title, is that agreed?
Agreed.
Carried. Clause 2, is that agreed?
Agreed.
Carried. Clause 3, is that agreed?
Agreed.
Carried. Clause 4, is that agreed?
Agreed.
Carried. Clause 5, is that agreed?
Agreed.
Carried. Clause 6, is that agreed?
Agreed.
Carried. Clause 7, is that agreed?
Agreed.
Carried. Clause 8, is that agreed?
Agreed.
Carried. Clause 9, is that agreed?
Agreed.
Carried. Clause 10, is that agreed?
Agreed.
Carried. Clause 11, is that agreed?
Agreed.
Carried. Clause 12, is that agreed?
Agreed.
Carried. Clause 13, coming into force, is that agreed?
Agreed.
Carried. Her Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows the Children's Law Consequential Amendment Acts 2019. I would ask a member to move that we report Bill number 206, the Children's Law Consequential Amendments Act 2019 without amendment.
I so move.
Mr. Cox moves. Is that agreed?
Agreed.
Carried. This concludes our business for this evening. Minister, do you have any closing comments?
Briefly, yes, Mr. Chair. With regard to the last two bills, I would like to thank the Law Reform Commission for the work that they did in consultation and preparing this piece of legislation and the background work that was provided. I know it took a lot of time and a lot of effort on their part. I attended some of the seminars and can't thank them enough for the good work that they did. I would like to thank as well, Mr. Chair, the board members that are here tonight, the members working at Hansard, security people, broadcast services, building services, the members that are sitting here tonight, as well as the staff from the various ministries that were here tonight for the work that they did in preparation for being here tonight, as well as the great work that they do all year round. Our province is well served by our public service, and I don't think we thank them often enough. So thanks to everyone, Mr. Chair.
Ms. Saar?
Thank you. I'd like to join with the minister in thanking those in broadcast services as well as Hansard, the staff that assist us through our committee work, as well as the members of the committee who are here this evening, the individuals who work for various ministries, as well as the officials for all of their work, not just this evening, but in the preparatory work in creating this legislation and many other pieces of legislation that we deal with, as well as the minister for his thoughtful comments this evening.
I would also like to join in thanking the officials and the members that are here and the minister and everybody for keeping it cordial, and especially those behind the scenes and those that keep me on track. So with that, seeing that we have no other further business this evening, I will ask a member to move a motion of adjournment. Mr. Kirsch has moved a motion to adjourn. Is that agreed?
Agreed.
Carried. The committee stands adjourned to the call of the chair.